Hello, and thank you everyone for joining us today. We are excited to have the launch of our Retain Kentucky and Employment First partnership of the Employer Seminar Series. So thank you all for being part of this today. And I am Kimberly Wickert with the University of Kentucky Human Development Institute. By way of visual descriptions, I'm a mid-career female with blonde hair, glasses. Today I'm wearing a camel-colored sweater and have the Retain logo behind me. And while the information contained in this presentation and accompanying materials is for informational purposes only, it does not necessarily reflect the views or the opinions of the Employment First Council, the University of Kentucky Human Development Institute, or its individual employees. And although we make every attempt to provide accessible, accurate, and current information, no guarantees are made to that effect. I'm going to put this in the chat, but please join us if you're able next month for our Employer Seminar Series, Myths and Facts, Hiring Persons with a Disability. Dina Wilson Kimbler from Kentucky's Office of Vocational Rehabilitation will be our subject matter expert on May 21st from noon to 12:45. Today, we are going to review ADA coverage, hear an employer's obligations when an employee discloses a disability, and discuss employer rights in the reasonable accommodation process. And I'm also excited to have our subject matter experts today, Barry Whaley, who is the project director of the Southeast ADA Center. And I will include a link to both Barry's bio, as well as Pam Williamson, who is the Assistant Project Director of the Southeast ADA Center. And I will include that information in the chat so you can learn more about both of them. And Barry and Pam, thank you so much for joining us. And any additional introduction you want to do here in a minute when I turn it over to you, I welcome you to do so. So excited to hear what you have to say. I'm also going to put our Retain Kentucky eligibility criteria and how to contact us in the chat. So with that, I am going to stop sharing. And again, welcome Barry and Pam from Southeast ADA Center. And thank you for those of you who put questions in your registration. Barry and Pam are going to answer those as part of the presentation, but I'll also be monitoring the chat as we go along and let them know as questions come up. So please ask. And with that, I'll turn it over to you, Barry.
All right, thank you, Kimberly. Thanks everybody for being here today. As Kimberly said, I'm Barry Whaley. I'm the project director at the Southeast ADA Center. Southeast ADA Center is a project of the Burton Blatt Institute at Syracuse University. A quick disclaimer, the contents of this presentation were funded by NIDLR, National Institute on Disability, Independent Living and Rehabilitation Research. Two things to remember. Number one is that the Southeast ADA Center is not an enforcement agency. We provide informal guidance based upon our research and understanding of the law. The other thing to remember is that we cannot provide a legal opinion to you. We are only providing informal guidance. So to begin with, what is the ADA? Well, oftentimes people think that the ADA is some sort of law of preferential treatment, and that certainly is not the case. The ADA is a landmark civil rights bill that guarantees equality of opportunity for people with disabilities, as well as people who might have an association with somebody who has a disability. The general public, typically when they think of the ADA, they think about Title III, places of public accommodation. They might see an accessible parking spot in front of the Kroger or an accessible bathroom. But really, there are 5 titles to the law. Title I are the employment protections, and those are the ones we are going to focus on today. Title II are state and local governments. Title III, again, those are those places of public accommodation, anywhere the general public goes to access goods, services, entertainment is under Title III. Title IV of the telecommunications provisions, and this is arguably the oldest part of the ADA. We have to keep in mind the ADA was signed into law in 1990. Nobody had any idea that we would be walking around with cell phone computers in our pockets in 1990. Title V are the technical provisions of the law, which includes who has enforcement responsibility. So under Title I, the employment protections that we're going to focus on today, enforcement falls to what's called the EEOC, the Equal Employment Opportunity Commission. You need to remember that under the ADA, disability is defined as a legal term, not a medical term. So the definition of disability under the ADA is a physical or mental impairment that substantially limits one or more major life activities. Need to keep in mind that there are slightly different definitions of disability. Vocational rehabilitation, for instance, defines disability slightly differently. If any of you are veterans in the audience, you know that the VA system of disability determination is quite different than this definition. So what we're going to focus on today are what are the employer's obligations when somebody discloses a disability. So the first and possibly the one that is the most confusing for employers is to recognize that a request for accommodation has been made. There is no magic word that somebody will use. They don't have to use the language of the law and say, I need a reasonable accommodation. They could say, I need help. When that happens, you need to recognize that there has been a request for accommodation made and you need to act on it. So how do you act on it? Well, the law is pretty specific in that you need to enter into what's called the interactive process, which is a big phrase that means that you have a good faith conversation with the employee who needs an accommodation in order to discuss where is the employee having difficulty, is this as the result of a disability, and explore what accommodations can be put in place in order for someone to equally do their job. You do have an obligation to confirm the existence of a disability, so you can ask for that medical documentation. We'll talk more about that on the next slide. You need to determine, are we concerned with the essential job functions or the marginal or tertiary job functions? So what are essential job functions? Those are the reasons why the reason why the job exists. They are the core function of the job. And marginal functions are those things that are adjunct to the job and don't require accommodation. Those can go away or they can be assigned to someone else. Under the interactive process, you need to investigate solutions. And, we don't always get it right, but we make a good faith effort to look at what accommodation might work for this particular individual. You need to then implement the accommodation, document the accommodation, and keep in mind that a couple of things. Number one, under documentation, you don't you need to make sure that the accommodation is in writing. I worked with a business years ago where the human resource manager did not put the accommodation in writing. And the only constant in business is that people leave and new people come. And so what happened is a new human resource manager came in, saw that the employee that I was representing was doing something a little differently and said, what's going on here? I said, well, we negotiated an accommodation. It is in place. Unfortunately, there was no record of that accommodation. Nobody ever bothered to write it down. So it is essential that you document what you do. Then finally, accommodation is not a one-time thing. You need to be ready to review and monitor that accommodation. many disabilities are progressive, right? So what may have worked for somebody in 2017 may no longer work for somebody in 2024. So you need to be flexible in monitoring the accommodation. Now, keep in mind, and this is important, at the end of the day, it is the employer's responsibility to determine what accommodation is put in place. An employee with a disability who arguably is the expert, right? And they don't have the final say in what accommodation is put in place. That is left to the employer, so long as what accommodation that is put in place is equally effective to the one suggested by the employee.
Barry, we do have a question. An attendee's asked, when speaking with several employees and employers, they seem to be very unfamiliar with the ADA and specifically requesting reasonable accommodations. Even after over 30 years of the ADA being passed, why do you think so many employers and employees are still so unfamiliar with the ADA?
That's a good question. If you don't mind, Kimberly, can we hold that question to the interactive part at the end?
Absolutely. Yes.
Okay. Thank you. I just want to make sure we get through this content because there's a lot here. So what are, lost my place here. Okay. So employer rights and responsibilities in the accommodation process. Again, you have to document what's going on. The employer can ask for documentation about a disclosed disability, but we need to keep in mind that that documentation has to be narrowly viewed in what disability needs to be accommodated. Because somebody may have 2 or 3 disabilities, right? But only one requires accommodation, and that is the documentation an employer has a right to get. The documentation has to be job related and consistent with the business necessity. So, I'm not so Pollyanna that I don't know that we live in a pretty litigious society, and the knee-jerk reaction is, give me all the documentation about your disability. No, the documentation that you have an obligation to get has to be related to the job and consistent with the need for that accommodation. You need to keep disability information and the accommodation confidential. And that means not putting that documentation in somebody's personnel file, but rather in a separate encrypted file that is, separate from the typical employee file. So employers don't have to, there are a couple of things, and this is important, that granting an accommodation does not result in eliminating the essential job functions. I like to use the example of, I run a company called Whaley's Widgets. Let's say that the standard is the essential function is you do 20 widgets a day. Well, somebody with a disability comes to me and says, I'm only getting 15 or 16 widgets a day. Does that mean that I can tell that employee, yeah, don't worry about it, you can just do the 15 widgets and that's fine? No. We don't eliminate essential job functions. My obligation then is to work with that employee to find an accommodation that employee can do 20 widgets the same as anybody else on my workshop floor. So you don't need to reduce performance standards. You don't need to get rid of the essential job functions. And this is important that, and we're going to be talking about substance use disorder in a few minutes. Let's say that somebody has some disciplinary action that has been taken against them prior to asking for an accommodation. Well, that doesn't erase those past disciplinary actions. If I wait, I start getting written up, and then I ask for accommodation, that's fine. My employer can then enter into the interactive process with me, but anything that's been disciplinary prior to that doesn't go away. It remains on the books. And then finally, before I turn it over to Pam, that an employer does not have to honor accommodations that create an undue hardship for the business. So what do we mean by undue hardship? That it is expensive, that it is disruptive, it changes the essential job function, it is just too complex to put in place, or something that would be dangerous or illegal. You don't have to honor an accommodation request. And so, Pam, just tell me how you want me to advance slides, and I will.
Thank you, Barry. Hello, everyone. My name is Pam Williamson. I am a middle-aged white woman wearing glasses, and I have curly brown and gray hair, and I have on a red and white top today. We're going to dive a little deeper here and talk about a disability inquiry. So, and this is a question or even a series of questions that are likely to solicit information about a person's disability or related medical condition. And if you'll go to the next slide, please. There are several phases related to disability inquiries that we need to look at. First of all, in the pre-employment situation, that's before an offer of employment has been made. So at the application or interview stage, no disability inquiries are allowed at all. So we need to make sure that all questions are legal and there are no disability questions being asked at this stage. And then at the pre-employment post-offer, so this is after the interview, after the employment offer has been made, disability inquiries are allowed only if the same inquiry is made of all candidates for the job category. So this needs to be done in a very careful manner and make sure that you're asking questions that are only asked of all of the employees in that same job category. And then you have employment, and disability inquiries can only be made if it's job related and of a business necessity. And as Barry just said a while ago, this is not a time to get all the information that you need on a disability. It needs to be very limited to a request for a reasonable accommodation and how the disability is going to affect the person on the job. Next slide, please. So now we're going to talk a little bit more about the rights and responsibilities of employees with substance use disorders. So we're going to now keep in mind that we are going to just do a very broad brush on this subject. So hang with me as we go through the next few slides. So next slide, please. So addiction is an impairment that can substantially limit a person in several different major life activities. And this could be brain and neurological functioning, working, learning, sleeping, eating, concentrating, caring for oneself, or remembering. So what does that mean when we look at alcohol addiction or the illegal use of drugs? Next slide, please. Because the ADA makes a very clear distinction between addiction to alcohol and the illegal use of drugs. Alcohol addiction is typically considered to be a disability regardless of whether the addiction is present or past. And an individual who has alcohol use disorder has an immediate protection under the ADA. Now, an individual who is using drugs illegally is not considered to have a disability when an employer takes an employment action based on that use. Individuals do have protections if they are in a recovery program and no longer currently using drugs illegally. And we'll be looking at some more terms related to this in the next few slides. Next slide, please. So as we stated, so alcohol addiction or alcohol use disorder is typically considered a disability, regardless of whether it's in the present or the past. However, the person must still meet the definition of disability. So they must still have a substantial limitation, so of one or more major life activities. And most of the time, the courts have upheld that alcohol use disorder is a covered disability. So, and there are a few courts, though, that still urge to look at these at a case-by-case evaluation of an existence of a major life impairment. So as the ADA is across the board, everything needs to be evaluated on a case-by-case basis. Next slide, please. So what does it mean for a person who has a substance use disorder who is in recovery? So this typically means that that the ADA protects a person who is in recovery and no longer engaging in the current illegal use of drugs. So in recovery, means that the person might be in a recovery program and they're no longer currently using drugs illegally. And also is no longer engaging in using drugs illegally, or participating in a supervised rehab program. So now the illegal use of drugs can be illegally using drugs such as heroin or cocaine or other drugs that are on the list provided by the federal government, or misuse of controlled substances such as opioids or morphine that have been prescribed to someone else. Next slide, please. So again, in recovery means from that a person is no longer engaging in the illegal use of drugs or is participating in a supervised rehabilitation program and is no longer using drugs illegally. So if a person meets these conditions, then they may be protected from discrimination under the Americans with Disabilities Act. Next slide, please. So what does the illegal use of drugs mean? Let's look at this again a little more carefully. First of all, it could be the use of illegal drugs such as heroin or cocaine, or the use of controlled substances such as opioids or morphine, but the person first either may have no prescription, have a fraudulent prescription, or is using more than is prescribed for them. Next slide, please. So what do we mean by current illegal drug use? Illegal use typically is meaning that has occurred recently enough to justify a reasonable belief that a person's drug use is real and ongoing problem. So again, current drug use is decided on a case-by-case basis. There was one court case in Texas that considered just 5 weeks after using drugs as being a current drug user or a current illegal use of drugs. And so we have to look at, if it's, a person tests positive on a drug test, then that person is going to be considered a current drug user. And current is not limited to the day of use, the recent weeks or days, but again, it's determined on a case-by-case basis. EEOC also states that the illegal use of drugs was recent enough to form a reasonable belief that a person's drug use is current and presents an ongoing problem. So we have to look at this very carefully and evaluate each situation on its own merits. Next slide, please. Now we get into a very sticky wicket. We have medical marijuana in state law. So if medical marijuana is legal under state law, then employers may need to consider reasonable accommodations for off-site use of medical marijuana under state law. However, an employee who is high in the workplace has no protections under federal or state law. Now, this really does present a dilemma for employers. So currently, 38 states have legalized medical marijuana and 18 states permit recreational use. But cannabis is still considered a Schedule I drug under the Controlled Substance Act of 1970. So even if an employee has a prescription for medical marijuana, the drug is still considered illegal. So that means the issue is really not totally clear. So we have then it gets even a little more murky. So we have a memo that was issued in August 2013 called the Cole Memo, and it was issued by the Deputy Attorney General James Cole from the U.S. Department of Justice. And basically it said that the Department of Justice would not prioritize prosecution in states with regulated cannabis distribution systems. So in other words, they shifted any oversight of cannabis to the states. And in May 2002, Attorney General Merrick Garland again reiterated that the Department of Justice will not prioritize prosecutions for marijuana use. So without the clear guidance from the federal or state level, employers may need to consider whether or not reasonable accommodations for off-premises cannabis use in states where it's legal. But again, the employer does have a duty of care to ensure a safe workplace, and employees who are under the influence of cannabis have no protections in the workplace. All right, Barry, I'm going to turn it back over to you to talk about direct threat.
I bet we'll have some questions at the end too.
I think so.
So the EEOC provides guidance on assessing what direct threat is, and we're going to take a minute here and look at what those are. So the ADA says that an employer can have qualification standards, and that would include a standard that says that an employee shall not pose a direct threat to the health and safety of people in the workplace. So this is quite true, for instance, of people who are working in states where recreational marijuana is legal or medical marijuana is legal. You have to balance direct threat. However, if a safety qualification screens out people who have a disability, then that might be a discriminatory practice. So if I am under the supervision of a doctor, I am prescribed medical marijuana, there is some sort of drug testing at my place of business, I test positive, then that is screening me out because of a disability, because I have a legal prescription. So that might become quite problematic for an employer. Under direct threat, the employer has to show that the direct threat presents a significant risk of substantial harm to the health and safety of people, of other workers, and that the threat cannot be eliminated or reduced by a reasonable accommodation. So there are 4 factors you need to look at in assessing direct threat. First is, what is the duration of the risk? How long do we anticipate the risk is going to last? What is the nature and severity of the potential harm? What bad things can happen, right? Number 3 is the likelihood that the potential harm will occur. So you need to, in each situation, assess how much harm will occur. And then 4th is, what is the imminence of potential harm? What is it? Is it something that is over time, or is it something immediate that I need to address right now? So the EEOC offers this guidance. If there is a direct threat that cannot be reduced to an acceptable level, an employer can exclude an employee from physically entering a workplace, but that does not mean that an employer can automatically terminate the employee. It goes back to that assessment of, if I'm barred from the workplace, you need to do an individual assessment of those 4 factors to determine, how immediate, the immediacy of the threat, and can an accommodation be put in place to ameliorate or limit that threat. So finally, if an if an employer determines that an individual with a disability poses a direct threat, you cannot exclude the employee from a workplace or take any other action unless there is no way to reasonably accommodate the employee. Now, that is absent of undue hardship. If the employer can show that having this employee in the business represents some sort of undue hardship to the business, that it's too costly or too extensive, then the accommodation would not have to be put in place. So that's the end of this. We have 13 minutes, it looks like, for your questions. And Kimberly, let's start with that first question, if we can go back to that.
Absolutely. Thank you both so much for that information as well. So the first question, and we have another one as well, was when speaking with several employees and employers, they seem to be very unfamiliar with the ADA and specifically requesting reasonable accommodations. Even after 30 years of the ADA being passed, why do you think so many employers and employees are still so unfamiliar with the ADA?
Yeah, so this is an opinion on my part and not based on research, but a couple of things come to mind. Number one is employees may be reluctant to ask for accommodation because of the stigma associated with disability, that I will be looked at differently. And for instance, let's say that I have been on the job a number of years and then I ask for an accommodation. There's also the fear that my employer might take some sort of retaliation against me. They might say, you should have told me this years ago. How can I trust you, right? And then they take some sort of adverse action against that employee because they just don't know. Employers, I think, looking at the employer side of it, I think employers just don't quite understand what the law is and how it applies. We come with a lot of baggage, right? A lot of unconscious bias about what disability is. If I say somebody has a mental illness, for instance, red flags go up. So an employer may have those biases and not understand that what their obligations are under the law. And Pam, I'm going to pause and see what you want to add to that.
Well, Barry, you've outlined quite a few things, and in addition to the employees who may not want to ask for accommodations. So there are also employees who don't know how to ask for accommodations.
Okay.
And so they want to make sure that they're doing it correct. And we actually talk to several people on a regular basis and explain the accommodation process to them. So that's another issue, is that there needs to be more outreach to both employers and employees about the steps to the accommodation process, and so that they can understand how to make it work in the workplace, so that valuable employees can be retained and then valuable employees can be hired.
You make a very good point, Pam, and we have the Southeast ADA Center. We have an 800 number where you can call and get guidance on the law. And every quarter, right, the number one topic of calls we get have to do with Title I, the employment protections, and how to get accommodation. Employers call us and say, what do I do? Right? Or as Pam said, the employee calls and says, I need an accommodation. I don't know how to ask for it. Or I feel my rights have been violated. Who do I talk to? Another question, Kimberly?
Yes. So John Costello asked for ADA return to work wise, how can an employer require 100% no restrictions to return to work? And I've seen this too, John, where someone will say, you know, a person can only return to work full duty. And then
Right,
we
so
have one
that,
more question too after that.
yeah, so that speaks back to what I said earlier about, yes, you can have qualification standards. But if those qualification standards seem to screen out people with disabilities, then that would be considered discrimination and would be considered illegal. You know, and again, 100% is based, I believe, on some false standard. I know that some days I give my employer 100%, but there are some days when you can't see it, but there's a beautiful picture window on the other side of my desk. I stare out and look at the birds. So I'm to say I am operating at 100% of productivity 100% of the time would just not be true. Pam?
So also too, so when we're looking at return to work, EEOC has been pretty clear that, you know, an employer should consider accommodations that an individual with a disability might need in order to be able to return to work. So that might be, you know, for part-time for a few weeks. It might be some modified job duties for a few weeks until the person can get there as 100%. So that is one of the things that I think needs to be thought through when talking with employers and employees who have been told that they need to be 100% to return to work. So, and so it's always good to open those conversations about reasonable accommodation.
And we have to look at, is the employee a qualified employee? And this is something we have not talked about in this particular session. But to be a qualified employee means you have the skill, the training, the education, the ability to perform the essential job functions. So again, going back to accommodating somebody, yeah, somebody may be returning to work and they need an accommodation in order to perform the essential job functions. And the employer has an obligation to investigate those essential or those accommodations so the employee can be every bit as productive as somebody else.
We have a few more questions coming in. I know we just have about 6 minutes left, but Bonnie asked, when a person who went to jail for drug charges, would that be an adverse effect when looking into a background check? He is in recovery and hasn't touched the drugs for over a year. He is trying to find a job, but his background is causing him issues.
So I'm trying to understand the question here. So he is in recovery, right? So he is no longer engaged in illegal drug use. So in recovery, he has protection under the ADA. That if he believes that an employer has discriminated against him or her, has discriminated against them because of that disability, then yeah, they would have protection under the law. Am I understanding the question correctly, Kimberly?
I believe so, from what I read. Yes.
Okay.
And then Sue said, not a question, a situation. Accommodation was not in writing. New management refuses to put accommodation in writing when asked. New management has begun disciplinary action. Employee has been there 3 years.
Well, that is clearly in violation of Title I of the law, is that if an accommodation request has been made, that employer has an obligation to enter into an interactive process. You cannot ignore the accommodation request and hope it goes away. I don't know, Pam, what do you want to, you look like you're pondering something.
Well, yeah. So, you know, and this is a situation where a person is potentially experiencing discrimination, and they've got options available to them so that you could, if they cannot work some things out with the employer, then the ADA does allow for the person to file a complaint with either the State Human Resource Commission or EEOC. And because if you file with one, then it's going to go, if you've got the State Human Resources Commission, which I think Kentucky does. So, it will kick in. So so those are, and it does take EEOC about 120 days to review the request and look at it. But it might be to the person's advantage to file that complaint so that they can and maybe go into mediation and so that they can get what they need.
Yeah, and that's an important point that you make, Pam, is that when you file a charge or when you get a charge complaint from EEOC, the EEOC prefers that you try to mediate with the employer prior to litigation. In fact, our next ADA, here's a shameless plug for you all. We have a monthly podcast called ADA Live, and our podcast for the month of May will feature Alessandra Rosa, who is with the EEOC district office out of Indianapolis, talking about EEOC enforcement and what happens when you file a complaint.
So I know we're only at a couple minutes, but John said he noticed that your risk analysis step 3 looked a lot like was drawn from risk analysis literature. And I'm going to summarize this, John, since we're short on time. He said it's nice for large organizations, but would seem to be difficult for smaller organizations. How is that usually handled?
I'm not sure I'm understanding the question.
He said, when you had step number 3, risk analysis on screen, I couldn't help but note that looked a lot like it was drawn from risk analysis literature, and would seem to. Go ahead.
Right. So what I presented to you, if you're talking about the assessment of direct threat, that is language that comes directly from the EEOC. So that's where the language comes from. Now go on, Kimberly. I'm sorry.
He just said bigger organizations often have OR, OA folks to help out.
Yeah, and many small employers do not. Now, the other thing we need to mention is that the ADA applies to employers that employ 15 or more employees. So if you are a very small business that employs 14 or fewer, in Kentucky anyway, you do not have to comply with the Americans with Disabilities Act.
Gotcha. Okay. And then I think you already answered this one. Somebody said they've run into many factory workers who say there are no light duty jobs available, even if they could do a portion of their job, so they're forced to stay off work. Would something like that fall under ADA potentially?
That somebody asks for light duty returning from an injury? Is that?
It sounds like that, but the employer says that there are no light duty jobs available.
Yeah, well, then the employer has an obligation to look at some other solution. Again, keep in mind, as I said earlier, the employee doesn't dictate what accommodation is put in place. The employer gets to make the decision so long as it's equally effective. So let's say that an employee is asking for light duty, but that may be impossible. So what accommodation can be put in place? More frequent breaks, comes to mind as an accommodation. Pam, do you have something to add to that? I want to make sure I put our information up on the screen.
Yeah, I just wanted to add, this is where we have to look. In fact, you're working with potentially 2 or 3 laws at one time. And
Yeah.
a lot of times if a person's out on workers' compensation leave, then the only thing that employer is looking at is workers' compensation. So we need to then, remind them that, the Americans with Disabilities Act and reasonable accommodations come into play. And it's possible if there are 50 or more employees at the employer's place of business, then Family Medical Leave Act may also come into play. So we have to just make sure that we're looking at all laws that apply versus just one that may just get put into a box. We need to make sure that all of them are looked at.
And then
with that, go ahead. I'm sorry, Kimberly.
Yeah, we just had one more question. So if you had more to add to
Yeah,
that,
if people hang on. Yeah, that's great.
So Lori said she works with claimants who receive short-term disability benefits and they want to return to work, but they're often told that the employer is only accommodating light duty for people who have workers' comp and not short-term disability. What are your thoughts related to that on ADA?
Well, again, this is when laws are going to need to work together. And so, a person that's out on short-term disability that can return to work part-time. And if they meet the definition of disability under the ADA and are still qualified for their job, then this is a request for reasonable accommodation at that point. And that pushes into action the interactive process. And in the chat, I put a link to a document from EEOC, the Equal Employment Opportunity Commission, about reasonable accommodations, and it addresses a lot of these issues that you're bringing up today. I highly recommend that that you take a look at it and get some more information, because we were only able to give you the very broad brush today.
Yeah, we took about 2 hours of content and put it into 35 minutes. So.
You did a great job, and thank you so much for answering all of these questions. I will send these resources out that you put in the link with the slide deck, as well as the certificate of attendance. So thank you both so very much for your expertise today. And the information is here to reach out, as Barry mentioned, to Southeast ADA Center to help walk you through any specifics that you may have going forward. So
we're
thank
a resource.
you.
Please use us. Yeah.
Absolutely. Thank you so much.